Thank you so much, sir. I should say it's my first experience to know about this law, and I should thank National Judicial Academy, Goda sir, and more importantly Amit. You actually saved my day. Your compilation prompted me to go through the excellent research articles on public interest litigation is there in that volume. It's every article has been gathered after a lot of effort. Everything is a precious pearl. When you get the time, whenever you get the time, please go through it. Now, this is what I thought I should tell about public interest litigation from what little I've understood. On reading it, I genuinely got one basic doubt. How could court get into this orbit called public interest litigation? This is the first doubt I have, principal doubt I have. I'll tell you the reason. Part 3, which talks about fundamental right, is something which is enforceable through a court action. It's possible. But when you come to part 4, please see Article 37. There is a clear caveat in Article 37. We should start from there to reach how this law has grown this far. It puts a caveat to say, the provisions contained in this part, which is part 4, shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in governance of the country, and it shall be the duty of the state to apply these principles in making laws. It therefore obligates a state to do a few things like social order in justice, social, economic and political space, right to work, public assistance, education, decent standard of life, enjoyment of leisure, social and cultural opportunities, nutrition, public health, growing space. It's a duty of the state to endeavor and achieve what best it can do, and you can't bring a court action and enforce it. That's the bar. But how did this public interest litigation then grow and occupy a space in part as part of judicial interpretation? I think this is the answer I have, at least. What they have done, they took Article 21 as the space to pitch and started to explore, expand and give up exponential growth. You have Article 21 which talks about life and liberty, which is a fundamental right. And many of these state duties conceived in Part 4 are all duties having nexus, close approximation to these life and liberties. And slowly courts started picking these duties and started dealing with Article 21, expanded it and said, they started to enforce it as a right. I think this is how this public interest litigation has grown over a period of time at a conceptual. This is a perspective. I need not be right, I need not be wrong. But this is one perspective which occurred to me on understanding what this domain field is all about. So without Article 21, it will be a non-starter. But with Article 21, it has become a great starter, and it is now, contemplated and challenged as many a times as an overreach. So this is the area in which public interest litigation has grown. Now, there are a few principles of ground rules of understanding this basic law of public interest litigation. It is a space which you actually make an inroad contrary to the elected majority's intention to do a legislation, and contrary to an experienced and a seasoned bureaucracy's policy-making powers. You have the legislative power, you have the policy-making dispensation through the executive. Now, when they don't act, it's the presumption. That's the second. One is Article 21 is the base pitch. Second one, the courts start stepping into this area saying that these two wings are not doing what is needed at a particular point of time. And therefore, we will step into this because we are redressing the cause of a general public or a general mass. And that's the way in which it has progressed. Now, the third reason for the expansion of this public interest litigation appears to be the non-access and non-availability of justice system for a majority of the people, the downtrodden, people who can't afford it. So many categories have been conceived in those articles. So, non-access, now judiciary says they are entitled, in the preamble they are entitled for justice. And these are all people, or these are all masses, they can't reach the court under normal circumstances. And therefore, now what do? We permit a third party action on their behalf. It's a beautiful, the growth in this last 25 years has been quite astonishing. And if you read it very methodically, it's an interesting subject to know as a matter of knowledge. So this is the third area. You create a space, court creates a space, non-access, they will continue to remain inaccessible, so allow a third party to act on their behalf and get justice. And we have moved into that space called public interest litigation. But what is said against it? Why are people saying, what are the pros and cons? We should put it that way. What are the pros and cons of this PIL? The advantage when you really do, when you invoke it, see, one condition which courts have to follow, all these articles very clearly say is, irrespective of whether it's an encroachment, whether is it a challenge to separation of powers, articles are all there in those extreme views also. Are we inroading it? All this is there. But one point which courts are allowed to get into this space is applying the doctrine of necessity in that particular transaction. That case before you, does it warrant an action, an involvement by the court? Doctrine of necessity is the basis for which a court can get into this. If a court gets into that, applying the doctrine of necessity, then it is considered to be a pragmatic judicial enforcement of rights. That's the terminology a judgment of the Supreme Court uses. If you do it on applying the doctrine of necessity, it becomes pragmatic judicial enforcement of rights. Then, allowing third party, I have already told you. Sir was also saying about epistolary jurisdiction. Epistolary jurisdiction is nothing but encouraging litigation through a telegram, through a letter. You don't have to do a formal petition, go to the registry, wait in the queue and mention before the court it's not reaching. All that is given a go by. There is a necessity, a petition or a letter is taken as the writ petition and a dispensation is made. This has grown essentially in the field of public interest litigation. Then, court assumes the power. How does it do? Dispensation happens how? There are some notes on that also. Courts starts issuing direction to public authorities. It says it actually creates policies in a very loose sense, or it actually occupies the space of policy making and says, I will start issuing you directions. Why don't you do this? So there comes the actual friction of separation of powers. Somebody has to do. So what is the criteria? Courts have said there are judgments. There are two cardinal principles for public interest litigation. Doctrine of necessity is one cardinal principle. The second cardinal principle is the court has to balance between inability to do an action and an unwillingness to do an action. That's the second principle which every judge has to apply when you invoke a public interest litigation exercise. One is necessity. Second is you have to find out in that case, can state do it or not as a policy? If state can do it and state is unwilling to do it and there is a need, then court can occupy that space and dispense justice on the ground of public interest as paramount consideration. But if state itself cannot do, burdening the state. In fact, he was giving an excellent example yesterday between a corrupt leader and a bold leader. A leadership where a leader is completely corrupt, but a leadership which is ensuring no terrorism, no secession activities happening in the state. Now, if a writ petition is filed with empirical evidence, then the tendency, or you go to the governor and then go to the president for a proclamation, tendency is to act on that application. Now, how do you balance these things in a democratic polity? So, unwillingness different from inability to do. That's one criteria. Why do they say so? The third caution uttered to courts through judgments are, they say, court should not substitute itself as a decision-making or policy-making body, however important it may be. That's the third limitation a court must pose to itself when it handles a public interest litigation work. Now, if you don't do all these three, where do we end? I start overreaching or overstepping I don't invoke doctrine of necessity, I don't invoke the test of willingness or inability, I don't see the space, then I still get into it and then start working on that. What happens? The aftermath, they have said, this will be nothing but clearly getting into violating the doctrine of separation of powers. If we say if we say that legislation cannot be interpreted, executive cannot interpret law, instead of courts doing it, if executive starts issuing declaration, this is the law, you follow, contrary to high courts, what happens? What happens to the system? So this is one concern, they say. The second quality which one of the judgments says is, this should not result in the public's mind or in a democratic polity's thought process as an undemocratic action, as an unelected judge determining public policy. This stamp is when you do a case on public interest litigation, you should not end up with this tag. An undemocratic process, unelected judge determining public policy. That's one concern. Third concern, they say, is lack of technical expertise in each field. Of course, there are counter judgments to say you can always empanel committees to assist the court should a need arise. That's the counter they try to give. Fourth one, the court starts presuming over a period of time. The habit of listening to public interest litigations regularly by the same bench, the tendency is obsession about citizens' rights, leaving out citizens' duty. It says temperamentally you will get into that area. So this is one area you should try to avoid. Now, then we will start philosophizing. If public interest litigations goes exponentially, it would only mean that the state is not doing anything in a fair way. That's the presumption you will ultimately end up. There is an elected body, there is an executive which is working, but judiciary now claims nothing is happening in a fair way. So we are a fair body. We will start substituting their space and start working into their space. They say this is something which you should avoid. And the last one, the caution they utter, if you repeatedly start interfering with executive policy thinking, then the charm of their power to deliberate, power to negotiate, power to finalize policies will start going for a toss. Every policy is now brought to the court. Every policy is being ridiculed by media. Everything you challenge it in a court. Then policy making power, the charm of doing a policy making, the charm of implementing the policy, it will be corroding the exteriors of and the finesse of an executive thought action. See, these are all a court judgment can reach where? All these articles give you a panoramic view where these court actions can actually lead you finally into this. Now, last 5 minutes or 10 minutes, so we need to discuss also. Sir was talking about the areas. In fact, there's a wonderful article, I think both of us read the article today morning, by Ashok Desai and Muralidhar, who is now a judge, a very senior judge at the Delhi High Court, a very respected judge. It's a wonderful article on public interest litigation. Now they carve out the areas, which he said, three big, see, it has grown. This law has, this justice system has penetrated in three major areas and done a lot of good for the country. One is human rights and liberties. Second is environment. And third is public accountability. Challenging the CVC appointment, inquiring about whether the CBI officer was right or wrong. Because these are all things which has something to do directly with the security and integrity of the nation. So these three major areas have really grown well according to all the others in common. But there are three areas which we should be very slow. We should in fact try to move away if there is a need. There are three caution areas which one has to bear in mind. Whenever issues relating to religious faith come up as a public interest litigation, I think courts have to be really slow. You cannot substitute, we can't substitute ourselves as religious leaders or non-religious leaders or irreligious leaders, whatever may be. See, there is a faith. Somebody follows some faith. We can't substitute it through a judicial interpretation to challenge that faith. I'll give you one simple example which happened in our state sometime, a year back. There is a very important temple, so sacrosanct that the consecration has to happen in a particular way and in a particular style. These are all there for hundreds and thousands of years, written. So, and somebody used to do it there's a tradition that somebody does it. So he decides the date. And for thousands of years that has been happening. Now the state government decides a date. It goes to him and says, this is the date on which you have to come and do it. He says, I can't come and do it on this date. This is not going to do good to the state, nor to its leader. Therefore, when you do it, you have to see these two things. These are not going to work and therefore I will not come. Then what happens? Then it comes into the media. Now how do you solve? Then you generate a public interest litigation. You file a writ petition on which date a temple consecration has to take place. And whom are you burdening? Like you, two judges sit on a bench to decide what is the auspicious day for a temple consecration. Where are we going? And they did. What did they do? They found out 4 affidavits. They found out which you go by rule of majority, democracy. So most of them have preferred one date. Okay, go by that date. What is the confusion? Writ petition is dismissed or disposed of. What happens? What happens now in history? Within 1 year, we have seen the result. Somebody utters a caution, don't do it. So matters of religious faith and sentiments, I think, cannot be something which which can occupy the domain of a public interest. That is one area which we should try to avoid. 2, corporate wars. This is a huge challenge. In fact, we are doing a few matters in the Supreme Court, quite august. And so, what do? Two corporate entities don't like each other. No, they don't fight. They don't go to the court and fight their issues. They involve 2 governmental agencies. And then generate 3 public institutions and file saying 15,000 crore scam, 25,000, you put whatever number you want. You don't have to substantiate it. You see the number, you invite. Now media, corporate war, this is a huge nexus. So as judges, whenever there is a court case coming on a corporate war, please identify whether it's a genuine case or not. This is one area, huge growing space for public interest litigation, which court should be very slow to act upon. And the third caution they utter is, you should not do anything which is gives you political publicity or publicity as general as we all like in the media. Publicity interest litigation and political interest litigation should be avoided. The last 2 minutes I'll wind up then, because you need to discuss. There are 2 areas I think we can really help the nation wherever, whether it's a male judge or a female judge. Especially there are women judges here. There are 2 areas whenever you get an occasion. One is education, and another is about our women's rights and emancipating our women and bringing them up. See, ultimately, whatever we may say, tradition, there can be an exodus of a Western thought into it, never mind, but we have our value systems and we can protect them, nurture them and carry them forward only through our women. Because a woman is one who connects 3 generations. She connects the in-laws, she connects the husband and she connects the children. She is the only connecting point. So the value system in a society revolves only around her. So unless we retain a good family system, we are not going to retain a good society. And unless we retain a good society, we are gone. So whenever there is an occasion available in this space, let's do something to ensure our girl children grow like our mothers and our value system. That's one area I thought I'll highlight. The last one, which is possible, when there is a chance for a public interest litigation, courts say, wherever state can monitor an action, that space can be occupied for a judicial thinking process. Wherever there is a need for a state to participate with its resources, courts have to be very slow. These are the broad distinction. Participate and then put your money, court has to be slow. It can monitor somebody's action as a nodal authority, then court can certainly enforce that right to ensure that state action actually happens so that results and outcomes are generated. I thank you once again, sir, and Amit, for these articles, and it was a pleasure. I spent some time yesterday, but I feel it's worth it. It was a learning curve for me. Thank you so much for this great opportunity.
Thank you, Mr. Venkataraman.